Good morning, good morning, good morning, everybody. I'm your host, the Supreme Litigant, and I'd like to welcome everybody back to Smart Lope TV. Before we begin, y'all already know the routine. If you haven't already, please go ahead and hit that like button, that subscription button, and turn that notification bell on. I'll give y'all a few seconds to do that. All right, so this will be the fourth installment of all 50 states holding the people are sovereign. Now, in some of these cases, it is not going to expressly say that the people are sovereign at all. What it is going to do is it is going to implicitly say it. So in other words, it's going to say it in another way without saying the people are sovereign. And the reason I'm doing that is because you need to learn how to interpret and read cases. So let's go ahead and jump right on into this. So we're going to start off with Kentucky. If there be authority for such action, it must be derived from the sovereign power of the people as delineated, I can't pronounce that word for nothing, in Section 4 of the Bill of Rights. Now, I want you to pay attention to this right here, because the word sovereign in this pair, hold on, what is it doing? Okay. The word sovereign is not going to be used in here at all. They're going to say it in another way. As a matter of fact, that's the whole purpose of them citing it. All power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, happiness, and protection of property. For the advancement of these ends, they have at all times an inalienable and indefeasible right to alter, reform, or abolish their government in such manner as they may deem proper. Now, even though this doesn't tell you that you can if you have to start a revolution against your government to change your government, you can. Even though it doesn't say that expressly, these right here, this, let me go back. Right here. All of this right here, this says that. That's what it says. Without it saying it expressly, it's being implied. It's telling you that you have a right to alter, reform, or abolish your government in such a manner as you may deem proper. That means if you have to start a revolution and you deem it proper, under the facts and circumstances, because they just simply refuse to do what they're supposed to do and they just think they can do whatever the hell they want, then yeah, you can start a revolution. This is, to be honest with y'all, this is really common sense, to be honest with you. But common sense isn't common. What is that, Louisiana? Yeah, all right. Here's another one. It is conceded by all that the people are the source of all governmental power. And as the stream cannot rise above its source, meaning the government cannot rise above its people, so there is no power above them. Sovereignty resides with them, and they are the supreme lawmaking power. Indeed, it has been declared in each of the several constitutions of this state that all power is inherent in the people. And this is true from the very nature of our government. There's the case right there. Go and read it, 1892. Let's go on down. Go to Louisiana now. All right. The Supreme Court of Alabama, in the case of Johnson v. Kraft, to which we have hereinabove referred on rehearing, declared the people themselves are bound by the Constitution, and being so bound are powerless, whatever their numbers, to change or thwart its mandates except through the peaceful means of a constitutional convention or of an amendment according to the mode therein prescribed, or through their exertion of the original right of revolution. The Constitution may be set aside by revolution, but it can only be amended in the way it provides. And that's a Louisiana case citing that Alabama case because that's a principle. It doesn't matter that it comes from Alabama and it's a Louisiana case citing it. It is a principle. So let me say this again. To everybody who's coming on my channel, if you're looking at the case citations that I post, I don't care what I don't even read the cases unless I feel like I need to. What I do is I post citations of principles. Principles are applicable everywhere. All right, that's what I do. I don't care what the case was about. Now, I would advise y'all to go and read the cases because that is going to strengthen your vocabulary in legalese, and it's going to help you draft your documents better, and it's going to help you understand cases a lot better. But again, I don't read cases unless I have to. If it's something new for me and it's a principle that I'm unfamiliar with, yes, I'm going to read the case. All right. A bedrock doctrine of constitutional law ordains that a written constitution is not only the direct and basic expression of the sovereign will, it is also the absolute rule of action and decision for all departments and offices of government with respect to all matters covered by it, and must control as it is written until it is changed by the authority which established it. That means the people. No function of government can be discharged in disregard. No function of government can be discharged in disregard of or in opposition of the paramount law. The state constitution is the mandate of the sovereign people to its servants and representatives, aka magistrates. No one of them has a right to ignore or disregard its mandates, and the legislature, the executive officer, and the judiciary cannot lawfully act beyond its limitations. The proposition is so elementary and so essential to an orderly, rational, and logical system of law, it requires no authority for its support. So it's like, this is so old, this is so elementary that we don't even need to cite cases to support this, to support our argument. That's what they're saying. Since the Constitution is intended for the observance of the judiciary as well as the other departments of government, and the judges are sworn to support its provisions, the courts are not at liberty to overlook or disregard its commands. So if the judiciary can't do it, then the legislature can't do it, and the executive can't do it. The courts are not at liberty to overlook or disregard its commands. Let me rephrase that. The trustees are not at liberty to overlook or disregard their fiduciary duties, or anyway, I'm going to say it the other way, its commands, or continuance evasions thereof. It is their duty to authorize proceedings to give effect to the existing Constitution and to obey all constitutional provisions, irrespective of their opinion as to the wisdom of such provisions and irrespective of the consequences. So what this just told y'all without telling you is what I've been saying all along, that all so-called three branches of government are administrative agencies of the people, because administrative agencies perform ministerial duties. Give me a second. Let me show y'all what let me pull up the definition for a ministerial act or a ministerial duty. Pause the video. I'll be right back. All right. So here it is right here. Ministerial act. An act performed by a government employee following explicit instructions in a statute or other legal authority, or directions given from a superior, the people, without exercising any discretion or independent judgment. Now, the judiciary, they can exercise discretion, but they can only exercise discretion because they were authorized to exercise discretion by the people in the Constitution. All right. All of them are performing ministerial duties, acts, whatever you want to call it. All of them are. when they are enforcing the Constitution, that is a ministerial act. All right, so let's go. Let me close this and we'll get back here. I think we were about right here. Yeah. Let me see. Yeah, okay. So now we finished with this one. Okay. So we're going to Maine right now. Going to Maine. Towns are mere agencies of the state. Now let me read this in another way, because I read what is implicitly said and what is expressly said. So it says towns are mere agencies of the state. Okay, so we can say the legislature is a mere agency of the people, because I'm basing that on the principle. The town was created by the legislature. So let's go ahead and continue. Towns are mere agencies of the state. They are purely creatures of the legislature, and their powers and duties are within its control. So let's read this another way. The legislature is a mere agency of the people. They are purely creatures of the people, and their powers and duties are within its control, or within the people's control. The legislature represents the sovereign power of the people and is therefore limited in its exercise of supreme authority only by an inhibition of the Constitution. The legislature has a large discretion with reference to its control of municipalities. The people have the people has a large discretion with reference to its control of the legislature. Is this making sense for y'all? Is this making sense for y'all? Since the people created the legislature has to do what the people say, and so does the judiciary and the executive, because they are agencies of the people. They are purely creatures of the people. Anyway, municipal corporations are but instruments of government created for political purposes and subject to legislative control. The legislative branch are but instruments of the people created for political purposes and subject to the people's control. You can say that. I think that's a reasonable conclusion. Let's go on. Previously, the power to legislate has been vested only in the House of Representatives and the Senate. But by the 31st Amendment to Maine's Constitution, the sovereign, which is the people, took back a power which the people vested in the legislature when Maine became a state. And there's the case right there. Yada, yada, yada. Excuse me. Let's go on down. We are on Maryland. The people of Maryland from 1776 until today have shown that they concur in the generally prevailing view, which we believe to be sound, that the people retain the sovereign power to rewrite their constitution, that the legislative process which lead that the legislative processes which led to and assist in the exercise of that power are not a part of the previously bindingly delegated powers conferred on the legislature by the people. That those who are selected to sit in convention and do the writing of the Constitution are selected directly by the people, and therefore are the direct agents of the people, rather than agents of the original government, which is the state. Yada, yada. I'm sorry. Agents of the organized government, which is the state. I'm sorry, y'all. What is that? This is Maryland. Okay. The sovereign power remains in the people. Two cases right there in Maryland. Also, if y'all are like, well, I don't want to get off topic on that, so I'm going to hold off on that. Massachusetts. All right, now I'm not sure. I think it was maybe in my first or second installment of these series of videos where I told y'all a magistrate means public servant. So I'm gonna read you an excerpt from a case out of Massachusetts that is basically confirming what I said. Because y'all need to know this stuff. They are public servants, aka trustees, aka attorneys appointed, to represent you, on your behalf in a manner dictated to them by their charter that we gave them, which is called the Constitution. Okay. All right. Or trust, whatever you want to call it. It is clear also that the term magistrates refers to officials of the executive branch. See Part 2, Clause 2, Section 1, Article 2 of the Massachusetts Constitution. There shall be a supreme executive magistrate who shall be styled the governor of the Commonwealth of Massachusetts. The term magistrates is also used to refer to members of the judicial branch. Marbury v. Madison, 1803. In addition, the term can be used broadly to refer to members of each of the three branches of government. See Article 5 of the Massachusetts Declaration of Rights. All power residing originally in the people. This is also telling you that the people are sovereign without saying that the people are sovereign. They're not expressly saying it. They're saying it implicitly. It's being implied in another way without actually saying it. All power residing originally in the people and being derived from them, the several magistrates and officers of government vested with authority, whether legislative, executive, or judicial, are their substitutes and agents, and are at all times accountable to them. All right, let's go down a little bit more. There's the case right here in Massachusetts. Let's go up a little bit more. Under Article 5 of the Declaration of Rights, the Commonwealth has a constitutional interest in ensuring that its elected representatives, we're going to say that its trustees, are substitutes and agents of the people who act only in their interests. A basic principle of our Constitution and of a Republican form of government is that the trustees are to be chosen by the people to represent them and their interests. The people, through the Constitution, established a legislative department comprised of legislators who are elected by the qualified voters inhabiting the districts that they represent. Let me see. The people also established an executive power exercised by the governor. The governor is emphatically the representative of the whole people, being chosen not by one town or county, but by the people at large. Right here, let's go on down a little bit more. All power residing originally in the people and being derived from them, the several magistrates and officers of government vested with authority, whether legislative, executive, or judicial, are their substitutes and agents, and are at all times accountable to them. Let's go on down a little bit more. Opinion of Holmes, so Justice Holmes, what is this? 1894. Confidence is put in the legislature as an agent of its principal, the people. So when you see these brackets right here, that means that this is not actually in the case. But what the so-called judge did was he had to base his opinion on a principle. I don't know what this case was about. I haven't read this case. I haven't even looked at it or pulled it up. But he seems to be basing it on some sort of principle. The core of the relationship between an agent and his or her principal is a duty of loyalty that the former owes the latter. The law demands that the agent shall work with an eye single to the interests of his principal. It prohibits him from receiving any compensation but his commission, and forbids him from acting adversely to its principle, either for himself or for others. This applies to all three so-called branches of government. Under Article 5, all governmental officials in the Commonwealth, as agents of the people, are bound to work with an eye single to the interests of their principal, the public. There's the case right there, 2018. We are in Michigan right now. In our Constitution form of government, the sovereign power is in the people, and a Constitution is made for the people and by the people. Right here, our duty is not to draft a Constitution, but to uphold the one adopted by the people. Nor is the question before us whether the Constitution should be changed, because it is allegedly an outmoded, horse and buggy contraption better suited to the needs of 50 years ago, when it was adopted, than those of today. If it should be changed, it must be changed by the sovereign power that created it, the people. This court does not have the jurisdiction to change the Constitution, and neither does Congress. Neither does your state legislatures. Neither does the executive. Let's go down. All right, Minnesota. In 1988, Justice, Lawrence Yitka, I'm not sure how to pronounce that, writing for our court in State versus Ham, a case interpreting the Minnesota Constitution, explained why the U.S. Constitution is a written constitution and why it is unique and special. Justice Yitka said, when the makers of our Constitution, U.S. Constitution, insisted on writing a Constitution, this was a unique idea in both the 18th and 19th centuries. However, the makers did so deliberately with the purpose in mind. England has never had any one written constitutional document. Its constitution consists of a series of significant documents in English history, starting with the Magna Carta. Other rights are protected by tradition on the assumption that Parliament will not tamper with those rights except at its peril. The American colonists feared the vagueness and uncertainty of such a system, with the possibility of abuse by future rulers. Accordingly, they insisted on enumerating permanently certain limitations of the powers of government. They specified that all government derives its power from the governed, and that all powers not enumerated as being given to the government were reserved in the people. 10th Amendment. Thus, where we have a clear understanding, as we do in this case, as to what our Constitution, Minnesota Constitution, meant in 1857, as defined almost contemporaneously in 1869 by this court, the only way that Constitution should be changed is by the consent of the people in the form of a constitutional amendment as provided by the Constitution itself. Now, that is not the only way to change the Constitution, by the way. Y'all should know, because I've said it a couple of times in these series of videos. Constitutions establish the machinery of government and are designed to protect the people's rights and freedoms through the basic and fundamental law. Importantly, they are not on the same level with ordinary legislative acts. While a legislature cannot bind its successors with an ordinary legislative act, constitutional law is designed to last into the future, to bind future generations. Constitutions are different from the ordinary law not only because they are concerned with basic or fundamental law, but also they are more difficult to revise than ordinary law. Unlike ordinary law, a constitution is not alterable when the legislature shall please to alter it. The legislature does not define the constitutional limits of its legislative powers, nor ultimately can it decide them. Within its powers, its legislative judgment is supreme. It does not divide its duty with the courts. and to it the courts ascribed competent knowledge. Nor in determining whether the legislation is within the constitutional powers of the legislature do the courts divide their duties with the coordinate branch of government. They cannot abdicate. If the legislature transgresses its constitutional limits, the court must say so, for they must ascertain and apply the law. Constitutions bind the people and their public assemblies to the basic and fundamental value choices embodied in a constitution. This binding of people to the basic or fundamental law embodied in a constitution reflects the people's mistrust of any governmental authority placed above them. It is through a constitution that the people protect themselves and preserve their basic rights and freedoms from the siren's song of the future tyranny of public assemblies or the ill humors that may emanate from the people themselves. We must not forget that the voice of the legislature is the voice of the sovereign people, and that subject only to limitations as the people have seen fit to incorporate into their constitution, the legislature is invested with the sovereign power of the people themselves. In other words, the provisions of a state constitution do not and cannot confer upon the legislature any powers whatever, but are mere limitations in the strict sense of that term, and the legislature has all the powers of an absolute sovereign of which it has not been divested by the Constitution. In determining, therefore, the constitutionality of an act of the legislature, the canon of constitutional construction above recited must be applied, together with that other equally as sacred canon. Together with that other equally as sacred canon, that every intendment must be indulged in favor of the constitutionality of an act of the legislature. All right, we almost done, y'all. So what is this? This is Minnesota too. Let me make sure. Yeah, we just got Minnesota and I think Mississippi, and I think that'll be it for this series right here. Because the issues before us center squarely on the correct interpretation of the language used in the Minnesota Constitution, the search for an answer must begin by looking at the Constitution's text, in particular the text of Article 1 and Section, looks like 9. Article 1 provides that all inherent political power in Minnesota originally resides with the people, and only the people have the right to alter, modify, or reform their government whenever required by the public good. The text of Article 1 could not be more clear. The ultimate power to alter, modify, reform government by amending a Minnesota Constitution resides exclusively with the people. When the text of Article 1 is examined together with the text of Article 9, it is not that difficult to ascertain the process the people have mandated to alter, modify, or reform Minnesota's government by amending the Constitution. The second time, the plain text of Article 9 provides the answer. In simple and straightforward language, the people have mandated in Article 9 that proposed amendments shall be submitted to the people for their approval or rejection at a general election. It is both logical and reasonable that the people of Minnesota mandated that the full text of any amendment to Minnesota's Constitution be submitted to them, because in the Constitution, the people reserved to themselves the ultimate authority to determine how they are to be governed. Right here, Minnesota. And let's go to Mississippi. Okay. According to the theory of the government of Mississippi, indeed, according to the principles which are universally regarded as fundamental in all the American systems of government, all political power is inherent in the people, and all free government is founded on their authority and established for their benefits. In other words, this is a Mississippi case telling you that the people are sovereign without actually saying it. It's being implied. They're saying it in another way. And hence, that they have an inalienable and indefeasible right to abolish their form of government, or to alter it in such a manner as they may deem most conducive to their welfare. They have therefore the undoubted right to delegate as much or as little of this inherent political power as they see proper, and to vest it in such agents or departments of government as they shall choose to designate. The sovereign power of this state or the people in their national or sovereign capacity have ordained a constitution, and by it have established a government, and clothed it with all powers which it possesses. It is therefore to the Constitution that we must look for the manner in which they are to be exercised, as well as for the nature and extent of its delegated powers. And hence, in all cases in which the acts of any department of government are brought in question, it must be shown that those acts are authorized by it, or they will be void. Mississippi, 1974. Now, this right here is very interesting, what I'm about to read y'all right here. This is probably my third or fourth time citing this case citation from another state, which means it's a principle, just to let y'all know. So this is a Mississippi case citing it. But I want y'all to just pay attention to what's being said. If a statute has a reasonable relation to a governmental purpose and is calculated to carry out some governmental design, the courts cannot strike it down as being arbitrary. Although members of such courts might think the system was inconvenient and that a better system could be devised. Statutes cannot be declared void merely because they are inconvenient and burdensome. If they are calculated to further governmental purposes. In Volume 1, Section 65, Sutherland on Statutory Construction, it is said, pay attention to this, y'all. Statutes cannot be declared invalid on the ground that they are unwise, unjust, unreasonable, or immoral, or because opposed to public policy or the spirit of the Constitution. In 1 Cooley's Constitutional Limitations, remember I told y'all about Cooley, at page 345, that learned author says that the moment a court ventures to substitute its own judgment for that of the legislature, in any case where the Constitution has vested the legislature with power over the subject, that moment it enters upon a field where it is impossible to set limits to its authority, and where its discretion alone will measure the extent of its interference. The rule of law upon this subject appears to be that except where the Constitution has imposed limits upon the legislative power, it must be considered as practically absolute, whether it operates according to natural justice or not in any particular case. The courts are not the guardians of the rights of the people of the state, except as those rights are secured by some constitutional provision which comes within the judicial cognizance. Protection against unwise or oppressive legislation within constitutional bounds is by an appeal to the justice and patriotism of the representatives of the people. If this fail, the people in their sovereign capacity can correct this evil. They are the only ones who can correct the evil. But courts cannot assume their rights. The judiciary can only arrest the execution of a statute when it conflicts with the Constitution. It cannot run a race of opinions upon points of right, reason, and expediency with the lawmaking power, nor can it consider the motive which inspired the passage of a statute in determining the question of its validity. Let me see. In one note to this quotation, it is said that if the legislature should pass a law in plain and unequivocal language within the general scope of their constitutional powers, I know of no authority in this government to pronounce such an act void merely because in the opinion of the judicial tribunals, it was contrary to the principles of natural justice. For this would be vesting in the court a luditarian, what's that? Latitudinarian. So it must be a variation of the term latitude or something like that. Latitudinarian authority, which might be abused and would necessarily lead to collisions between the legislative and judicial departments, dangerous to the well-being of society, or at least not in harmony with the structure of our ideas of natural government. All courts can do with odious statutes is to chasten their hardness by construction. Such is the imperfection of the best human institutions, that mold them as we may. A large discretion must at last be reposed somewhere. The best, and in many cases the only scrutiny, is in the wisdom and integrity of public servants and their identity with the people. Governments cannot be administered without committing powers in trust and confidence. On page 351 of this same work, it is said that nor are the courts at liberty to declare an act void, because in their opinion it is opposed to a spirit supposed to pervade the Constitution, but not expressed in words. When the fundamental law has not limited, either in terms or by necessary implication, the general powers conferred upon the legislature, we cannot declare a limitation under the notion of having discovered something in the spirit of the Constitution which is not even mentioned in the instrument. All right. So I think that one was good. I kind of want to read y'all something else. Just to get this drilled in y'all minds. So give me a second. Let me pause the video, and I'll be right back. All right, y'all. So this will be the last excerpt from a case that I read. This is the case citation, Perkins versus Alabama, 45 Alabama 103. It was decided in 1870. Again, this is why you need to read old cases, because what I'm about to tell you is you're not really going to see it in new cases. I doubt it. You have to read the old cases. But just to show y'all that this is Perkins versus Corbin, there it is right there, page 103, Perkins versus Corbin, Alabama Supreme Court. And it starts on page, I think, 8 or 9, what I want to point out. I think it's 9. Yeah, right here. Now, I did a video on this on my YouTube channel. It's called The People versus the Legislature. All right, so let's get started. We admit broadly the doctrine that the people are supreme in the state, subject to the concessions of power made to the coordinate department of the state. What they just said without saying it is that the people are a coordinate department of the government. But it does not follow from this admission that they have made the legislature supreme. For the security of the judiciary itself, one of these great coordinate departments, the people in their constitution, have expressly guarded and restricted the power of the legislature. For the security of the judiciary itself, one of these great coordinate departments, the people in their constitution, have expressly guarded and restricted the power of the legislature. This department, the legislature, has always claimed to be the people, and it has often invaded the rights and authority of other departments. They just can't control themselves, y'all. They just can't control themselves, man. They can't. They're like little children who just throw tantrums when they can't have their way. Like when you come in and you demanding to know the nature of the cause of the action, or the nature of the action, and they go to calling you a sovereign citizen and calling you crazy and threatening you with contempt of court because they can't have their way. They have zero discretion to ignore you when you demand to know the nature of the action. In other words, when you demand to know the jurisdiction in which the case is being prosecuted under. They have zero discretion to ignore that. But that's what they do. They ignore it. They don't want to tell you. Anyway, it once elected, it being the legislature. Let me read. I got to read this again, man. This department, the legislature, has always claimed to be the people, and it has often invaded the rights and authority of other departments. It once elected the judiciary, but the people took from it that power. It's not yours. It once had unlimited control over the tenure of inferior judicial officers, judges, and the people restricted this power. The people now elect all the judges, and every man duly qualified and placed in office by the votes of the people is a judge. The people have further restricted the power of the legislature to remove the judges, not only by securing the tenure of their offices, but also by prescribing express rules and conditions in respect to removals by the Constitution. They had to get they just got so ridiculous with it. They had to give them rules because these people think they can do whatever they want, man, and they can if you're ignorant, if you don't know your rights. This is why you need to study and read. In this case, the legislature has legislated so as to remove a judge from office. They have abandoned the judicial functions of address and impeachment conferred on them by the Constitution, and have ignored the rule requiring a 2/3 vote of each house, and forgotten that the governor must remove the censured incumbent, and have attempted to vacate his office by repealing the law that established his court. Now, for everybody who's on my YouTube channel, this is some of these idiots in the comments that keep telling me that legislatures can't establish courts. No, they can't establish courts. Not in the sense to where these are courts of general jurisdiction, and in other words, these are courts of the judicial branch of government. No, they can't establish those kinds. What they can establish is administrative agencies that they call courts and look like courts and they function like courts. That's what they're doing. A municipal court, that's what a municipal court is. Any type of, I don't care if it's a district court, circuit court, a U.S. district court, a U.S. court of appeals, United States Supreme Court, I don't care what kind it is. If they are in there exercising jurisdiction or appeals under statutes, that's an administrative agency. Because members of the judiciary do not need statutes to act. They get their authority to act from the sovereign, which is the people. They are created in the Constitution. Anyway, I got to read this again because they just think they can do whatever they want to do, y'all. The people have further restricted the power of the legislature to remove the judges, not only by securing the tenure of their offices, but also by prescribing express rules and conditions in respect of removals by the Constitution. In this case, meaning the case that at bar, the case that I'm reading right now, the legislature has legislated so as to remove a judge from office. They have abandoned the judicial functions of address and the impeachment conferred on them by the Constitution, and have ignored the rule requiring 2/3 vote of each house, and forgotten that the governor must remove the censured incumbent, and have attempted to vacate his office by repealing the statute that established his court. Suppose that on the next day after the law had been repealed, another law of the same import had been enacted. Who would have been the judge of this new court? It would have been Judge Corbin. His office had not expired. He was still a judge, and the new enactment provided the very tribunal in which he was authorized to preside. the legislature did at the same session organize a new court providing for the election of a judge with the same tenure of office, the same salary, and to be paid in the same way, and only restricted the new court in its jurisdiction by calling it a criminal court for Dallas County. So let me look, man. They can name it whatever they want. It's theirs. They created it. They can call it the Supreme Court of the most supremest courts, of the supremest of all courts in the entire galaxy. But if they're in there enforcing statutes and following statutory procedures, that is an inferior court, aka administrative agency, aka territorial court, because they can only adjudicate things that come within their territorial jurisdiction. They're territorial courts. They're created by statute, just like municipalities, towns, cities, counties, incorporated. They're territories. They're created by statutes. Territories created by statutes. You don't need statutes to create towns and cities and counties. You don't need statutes for that. Or state. You don't need it for that. It can be used for that, but you don't need it for that. The area of its jurisdiction was the same with the city court of Selma. Here are two courts identical in jurisdiction as to the boundaries of the district court and identical as to their judicial power, except that the substituted court has less power than the one destroyed, with judges paid the same salary and elected each for 6 years. I ain't gonna read all this. If y'all want to read it, y'all can go and read it. But I'm just trying to show you that the people are suffering. You need to wake up. You need to know your rights, because these people are not going to stop when they start violating your rights. They're not going to stop. You have to cost these people money, and a lot of it. Anyway, that'll be it. The Supreme Litigant is out. Peace.